Good morning. Good morning, everyone. Firstly, apologies for the delayed start. Welcome. Welcome to the SACAP Code of Conduct webinar. My name is Singalaka Bongela. I am a registered professional architect. I do also have the honor of chairing the investigating committee at SACAP. I do, however, wish I had the capacity to investigate further into how to stop making it so cold these days. So I trust everyone is keeping warm, and I do think Registrar, our terms of reference at the investigation committee need to expand. So welcome everyone, indeed, to each and every one of you to this webinar. By you being present in this webinar, you are taking the time, you are taking the initiative to equip, to inform, and to empower yourself about the regulations of the profession that you are registered to. You know, it's so important that all registered persons know the code of conduct that they are declared to. It's very alarming that in so many of the cases of improper conduct that we investigate, the registered persons don't know the code of conduct. So thank you for being here. Thank you for taking the initiative. As the investigating committee, our mandate is to investigate improper conduct by registered persons. And these are registered persons of all categories, whether you are a candidate, whether you're a draftsperson, whether you're an architectural technologist or technician or architect. Our role is to investigate. Basically, the overriding objectives of the code of conduct is to strive for excellence in the architectural profession. It's to promote the environment against unsound architecture practice and the delivery of service to the public with due care, with due skill, with diligence, as well as integrity. So we have to know all of our rules and our code of conduct. From the minute you step into your office, it has to be part and parcel of your bread and butter of a registered persons. The rules are grouped, code of conduct rules are grouped in 8 categories of practice, each category having numerous subsections and specified rules to abide by. For ease of reference, always know that our code of conduct appears on our SACAP website. Please ensure to know the rules if you are practicing professionals. Why do we abide by the code of conduct? Why does any professional have to abide by the code of conduct? Well, there are a few reasons. One is to maintain trust and credibility. It promotes honesty, it promotes integrity, it promotes fairness, which builds trust between the professionals and the public. Number 2, it promotes accountability. It sets a clear expectations, making it easy to hold individuals accountable. Number 3, it protects the reputation of the profession. The actions of one professional can affect the perception of an entire industry. Adhering to the code helps protect and uplift the public image of architects. Lastly, it guides the ethical decision-making. Code of conduct serves as a framework for making ethical choices. So we plead to all registered professionals to please comply with our code of conduct. In this code of conduct, excuse me, you see this cold weather is bringing on flus. Of this code of conduct, it is the Architectural Professional Act 44 of 2000. Specifically, currently, if you are practicing as a professional, you are referring to Board Notice 7 of 2021. I'll read an extraction of this Board Notice 7. It's an overriding obligation under the rules that in carrying out professional work, a registered person is expected to act competently with integrity, It's therefore expected that a registered person shall refrain from conduct which would, in the opinion of SACAP, be detrimental to the esteem, dignity, or professionalism of the architecture profession, or would tend to bring the profession into disrepute. Once a registered professional hasn't aligned themselves to the code of conduct, once you are shown to be unprofessional, when you don't fulfill your obligations to your client, you are seen to be dishonest in any form of manner, and there's evidence of such. Once this happens, any member of the public has the right to lodge a complaint at SACAP. Once it happens, it comes to the investigating committee. This is where we step in. So in terms of the investigating committee, SACAP's mandate is to serve as registered persons and to protect the public. Those are the main objectives and mandates of SACAPs. The protection of the public part of that mandate is the responsibility of the investigating committee. So the committee formation is formed by legal compliance officers and architecture professionals. What happens is that we receive a complaint from the public through our legal compliance officers. Once we receive the complaint, we request evidence. When we receive the evidence, we allow the registered person to respond to all the allegations. After investigating, as the investigating committee would recommend charges to the disciplinary tribunal. The disciplinary tribunal will then decide on the charges to prosecute and the sanctions to implement. This could be a fine against you. This could be a suspension of your registration. But either one of those, once you have been found guilty by the disciplinary tribunal, the outcome is recorded and it becomes public information. Your name as a registered person appears on our website and in the government gazette for the public to see for a prescribed period of time. And no one really wants that. No one really wants a bad record. Hence why we are here. Hence why we are educating ourselves on the prescriptions of the Code of Conduct. So thank you for taking the initiative. As part of today's informative session, I'd like to give you some common cases that appear within our investigating cases. So the most common, registered professionals not fulfilling their obligations to their clients. That's the main one. RP will receive a payment and either don't do the work or they delay in submitting the plans to the client or to the municipality. We know municipal submissions take long, but keep the client informed and perform in a reasonable time. Keep on checking on the municipality what the issue is, if the plans have been rejected, and so forth. So once the case comes to us, for instance, your client had an extension of a garage that you haven't submitted at the municipality, or you are late on your submission. During the investigation, if the RP says that they've submitted at the municipality, we have direct links to the municipalities all over South Africa. We pick up the call, we request the information. For instance, is ERF 224 at 127 Vilakazi Street in Kiskamahoek. Municipality, when last was a building plan submission done on this earth? And they'll confirm. If they say it was 1992, which majority of you weren't necessarily born yet, or they'll say on the 1st of February, for instance, 2024, but it was rejected because it encroached on the rear building line, for argument's sake. And the RP didn't make the corrections, the RP didn't follow up, and you've left your client abandoned when they've paid you an amount. Then you are charged for not fulfilling your obligations with diligence in reasonable time. So once your client comes to SACAP to lodge a complaint, we firstly look at the registered person's record. Is the registration active? Are they allowed to practice? Are their annual fees up to date? Are their CPD points up to date? Do they have any previous cases against them? After establishing that, secondly, we look at the contract between both parties. Was there a written agreement in terms of Rule 4.1? And 99.9% of the time, these cases, there's no written agreement with all the requirements of Rule 4.1. Has the scope of architectural work been established? Has the allocation and limitations of responsibility been stipulated? Is there provision for dispute resolution? What we've seen in most of these cases, the registered professional will always have their fee. The fee is always there. Usually, they'll send a quote to the client. The client will agree, all right, I'll pay 10,000 for your garage extension, Mama Zubuko, and they'll proceed with the work. That is not how our code of conduct prescribes. But I will let my colleague, Bessie, expand on the importance of a written agreement according to our code of conduct. So please, you have to ensure before you do any architectural work, you have to put the terms in writing. Thirdly, once the complaint has come in, we'll also investigate further. We'll look at your company. When was it registered with CIPC? Rule 5.1 of our regulation stipulates that you need to register your company with SACAP within 30 days of the registration. So we'll look into CIPC, when was it registered? We'll look if it's registered at SACAP and if that happened within 30 days. I know sometimes when we qualify, we get registered, we open our companies and we proceed to practice architecture, but we need to inform SACAP about your company. Please ensure this happens. Rule 5.1. Further on, we see the quote. Most of the times they'll send a quote to indicate how much their fees are for the architectural work. That quote that you sent, does the letterhead display all the required information according to Rule 511? Does it have a practice name? Does the name of the principals and their registration numbers and category of registration appear? And 99% of the time, the letterheads don't conform. So you came because Masabuko's garage wasn't submitted at the municipality, but we find out that the contract hasn't been signed correctly. The correct information on the letterhead doesn't appear. There's so many aspects that one needs to consider. We also go further. We look at your company website. We look at your Instagram, your X, TikTok, even your Snapchat. If you're registered as a candidate, if you're registered as a draftsperson, as an architectural technician, or a technologist, and you refer to yourself as Sketch Architects or Jimmy the Architect on your Snapchat, we'll pick that up and we'll see that you're contravening Rule 1.5, which says they shall not misrepresent their academic and professional qualification. So the complainant will come to SACAP with one grievance and will pick up 4 or 5 after that. So it's so important to all registered professionals for them to know the code of conduct. I will then hand over to my colleague, Bessie, who will further elaborate the terms of appointment, municipal corrections, and communication with client. Thank you, Ms. Bessie.
Thank you, Chair. Thank you for your insightful opening remarks on the Code of Conduct and the recurring contravened rules. Your guidance reinforces the importance of ethical standards and professional integrity in our field. We truly appreciate your commitment to upholding these principles. And again, thank you to all who are attending today. My name is Bessie Hlope, and I'll be taking you through Rule 4.1, 4.6, as well as 4.14 of the Code of Conduct. All right, Rule 4.1 deals with the terms of appointment. So the common contraventions of this rule that registered persons normally do is that they do not conclude a formal contract between themselves and their clients, then which the only agreement with their client is usually a verbal one, or they have, for example, they give their client an invoice, they give their client a quotation as a form of the agreement. And then obviously this fails to comply with the rule in its entirety. Secondly, registered persons would have their terms of appointment in writing. However, those terms of appointment that are in writing would fail to include all clauses that are found in Rule 4.1 of the Code of Professional Conduct. And then, for example, they won't have the termination clause, the dispute resolution clause, and also they fail to provide for the professional indemnity clause. So in order to assist registered persons who cannot afford legal fees or to draft the said contract, amongst other constraints, SACEP has developed 2 contracts that registered persons can use in their day-to-day dealings with members of the public. The said contract can be downloaded on the website. There is one for high complexity projects and one for low complexity projects. So you are welcome to also request our assistance today in order for us to share with you this terms of appointment. They are in Word version so that you can be able to amend them to suit, obviously, the terms of agreement between yourself and the client. The important thing is that it covers the whole Rule 4.1, it's in entirety. And then I'll move on to Rule 4.6, which deals with attending to municipal corrections. So the common contraventions of these rules is that registered persons are appointed to obviously prepare building plans and to obtain approval thereof. And then they are fully paid by their clients. However, they fail to attend to the corrections that are required by the municipality, leaving members of the public stranded with unapproved building plans. Secondly, Rule 4.6 of the Code of Conduct makes it mandatory for registered persons to attend to all the requirements of the municipality on the prepared building plans within a reasonable time. Registered persons are once again urged to make follow-ups with the submitted plans, as in most cases, you might find that these corrections and amendments are sent to them, and only they can attend to those corrections, and obviously it cannot be left to the client. You might find in such instances the client is the one who's saying, I'm the one who's following up with the municipality, I'm the one who's following up with the registered person, and I'm not getting these corrections. So we have initiated entering into MOUs with various municipalities. This relationship seeks to ensure that SACEP can address municipalities on issues that are faced by professionals, such as delays. These challenges can be communicated to our stakeholder relations department for intervention. Please note that during the investigation, we look into the steps that you take as a professional to assist your client when you are saying you are facing delays with the municipality. So I therefore suggest that you do keep records of communication with the municipality, keep all your follow-ups in writing. This will show on our side that you were actually following up with the municipality and that the challenge was either on the side of the municipality. And then I will move on to adequate communication with your clients. RPs are registered persons are expected to keep their clients informed in writing about the progress and work undertaken on their behalf within a reasonable time. Clients ought to be informed of any issue which may affect the quality or the cost of the project. This is Rule 4.14 of the Code of Conduct. Clients usually complain that registered persons are not answering calls, WhatsApp messages, and emails. We see situations where even the clients go as far as to try and call registered persons using different numbers, and that's how they see that they are specifically being ignored. We see situations where registered persons are even blocking their clients when they keep following up. And then obviously here we also see situations where registered persons are informing their clients that, no, I'm going to do this on Monday, Tuesday, and so forth. But you find actually that they end up not meeting those timelines, and they end up not communicating with their clients, leaving it to the client to constantly follow up with the registered person. And this is very unfair, obviously, because monetary issues here are involved. Registered persons are urged to be proactive when it comes to providing written updates to their clients. Take note that the rule requires that you keep your client updated in writing. This will also serve as evidence when we are conducting investigations on your side as a registered person, where you can show that you were actually updating your client. Registered persons are cautioned to act professionally at all times and not to swear at their clients. Please note that clients do submit WhatsApp communication and all other forms of communication when they are submitting complaints to SACAP. So we are seeing these communications, and we urge you to obviously not to swear at your clients. This is very unprofessional. Effective communication helps to build strong working relationships. It encourages collaboration and promotes a positive work environment. Registered persons must ensure that after each milestone, the client signs off where the scope of work involves more than one stage. This rule extends to informing clients in writing of any issue, that may significantly affect its cost or its quality or cost, and other considerations which may substantially affect the project. This rule assists registered persons in keeping track of their milestones on the project, and also assists whereby the client alleges that such work has not been done, and such proof can be produced to confirm the performance of such milestones. Signing off plans by clients before the plans are submitted is also important, as it is also a form of proof that the client has seen the plans and has approved them as they are to be submitted. This provides the client with courage and transparency with the work being done during the project. Registered persons often fall victim of this rule by noticing significant changes in the progress of the work and not informing their clients. Budgets get exceeded and clients are left to fit the bill. It's important to inform your client of any changes that may affect, obviously, the budget, and let them know and be aware and make a reasonable, informed decision on the matter. And obviously, if you have this communications in writing, it will serve as proof that the client was fully aware of the changes that we were making affected the initial budget. This avoids the he said and she said situations. It is required that registered persons keep their clients informed in writing to prove that this was indicated to the client and that this was the client's response and final decision. So I will just cut it by saying that, in short, you can contact us and we can provide you with the terms of appointment, because we do not see a need anymore for this rule to be constantly being part of the rules that are being contravened by registered persons. And we are obviously available to help you with these contracts that have been drafted by SACAP. And also, effective communication with your client is very important. Keeping your clients informed of any updates on work is essential. And also, please remember to attend to municipal corrections within a reasonable time. Be truthful to your clients about when you are going to attend to corrections, and actually do that, because consider that this money that these clients are paying you, obviously, sometimes it's their life savings for their dream homes. And obviously, money involved means that you need to provide a professional service. So thank you very much. That will be my cut off for now. Thank you.
Thank you, Ms. Bessie. Thank you for that presentation. As you can see, RPs, municipal connections, communication with your clients is the main reason why there is any fights or disgruntledness when it comes to your clients. Please ensure that the terms of appointment are in writing. Our second presenter is Kagelo Mishile, who will be discussing the establishment of a practice working with unregistered persons. Thank you, Ms. Kagelo.
Thank you, Madam Chair. I will be taking you through, my name is Kagelo Mashile. I will be taking you through the establishment of a practice. What we have seen is that we are receiving a lot of complaints against registered persons where they failed to list their practice with SACAP. So what SACAP has done is that there is actually a form that registered persons can complete in order for them to list their practices. This form, it doesn't come with cost. registered person can easily list their practice with our registration unit. So what they need to do is just to send an email to info@sacapsa.com and request for that form in order for them to complete that form. Because Rule 5.1 makes it mandatory for registered persons to list their practice within 30 days of its establishment. So what SACAP does is that when we receive complaints from members of the public, we look at the practice, if the practice is listed with SACAP. And then if we find that that practice is not listed with SACAP, that constitutes an improper conduct. So what you need to do as a registered person, you must ensure that you list your practice with SACAP. It comes at no cost. And also looking at Rule 5.6, this is where registered persons are performing architectural work with persons who are not registered. So we have seen that this improper conduct or this conduct is recurring. So we want registered persons to be aware of the fact that they may not conduct any work with a person who's not registered. So in order for them to be able to conduct work with a person who's not registered, they need to first seek permission from SACAP. So if you are found to be doing architectural work with a person who's not registered with SACAP, and what SACAP will do is that this will constitute an improper conduct. So we are not saying, SACAP is not saying that you may not entirely conduct work with someone who's not registered. SACAP is saying that in order for you to do that, you need to first seek permission. So we have seen that most of the time, we don't have those requests for permission. So what you need to do is that if you want to work with someone who's not registered, you must seek first permission. And then if you don't do so, and then SACAP finds out, it will constitute an improper conduct. And also, one of the rules that is seen to be mostly contravened by a registered person is the contravention of Rule 5.10. So what Rule 5.10 says is that a registered person in the category of a candidate shall not establish an architectural practice, act as a principal, or is still calling an architectural practice. So we have seen that candidates are operating architectural practices. So what Rule 5.10 is saying that if you are registered in the category of a candidate, you may not conduct an architectural practice. So this is just to say to candidates, it may happen that you just come back from school and then you want to register a company. What SACAP is saying you must wait up until you are in the category of a professional. So if you are found to be a person registered in the category of a candidate and you have established a practice, it will constitute an improper conduct. So if you're a candidate, please don't do that. And then what we have seen also is that registered professionals are renting out their registration numbers to unregistered persons. This constitutes an improper conduct. So what SACAP has seen is that registered persons are renting out their registration numbers to people who are not registered. So this, what it does is that if SACAP finds that out, it will constitute an improper conduct. And then also we have seen that we've seen complaints where a registered person registered in the higher categories are giving their registration numbers to people who are in the lower categories, or they are also signing off plans that they did not prepare in order to help someone who's in a lower category. So SACAP is saying that you may not do that, and if you are found to be doing that, you are constituting an improper conduct, and also taking into consideration the IDOW. And then also we have seen contravention. Okay, yes, also we have seen contravention where registered persons sign off plans that have been copied somewhere. So what SACAP is saying is that what you need to do is that you must also be alert of the Copyright Act. So when you are doing that, when you're signing off just plans, you must also be you must also consider the Copyright Act. And we may move to the next slides. Thank you. Okay, and also we have seen that registered persons are failing to submit building plans to the municipality. As my colleague before has said that members of the public trust registered persons with their life end monies because they want to see their dream houses. So what we've seen is that members of the registered persons are appointed to do certain work, but however, they fail to do as per appointment. They fail to submit building plans to the municipality. They fail to honor their agreement. So we've seen that actually a lot of complaints emanate from failure to submit building plans to the municipality. And not only are registered persons just failing to submit building plans to the municipality, they also lie to their client. They will lie to the client and say that no, your plan has been submitted, you're just waiting for approval. And then a member of the public will go to the municipality and find that their plan has not been submitted. So we are seeing a lot of complaints emanating from contravention of Rule 1.2, where registered persons are failing to submit building plans to the municipality, irrespective of being paid for the work. So what we can really say is that when you accept work, just make sure that you honor your agreement, you submit the plans to the municipality. And then also what we've seen is that there's fraudulent use of local authority stamps perpetrating that the plans have been approved. So what we've seen is that registered persons are lying to their client. So we have seen that a member of the public will come to SACAP and say, I was told by a registered person that my plan has been approved. And then moreover, there's even a stamp that says plan has been approved. And what they use previous approved stamps to mislead their client to say that no, the plan has been approved, whereas the plan has not been approved. So these are the types of complaints that we receive from the members of the public. So we are saying that when you accept a mandate, when you have been paid for the work that is expected from you, do as per obligated. Don't misrepresent facts. And then if the plan has not been approved, be honest to your client. If you have not submitted the plans to the municipality, be honest to your client and say, though, I have not submitted the building plans here to the municipality, other than just faking and misrepresenting facts. And then we can move to the next slides. So also what we have seen is that there's a contravention of Rule 1.7 that says a registered person shall not engage in any act of dishonesty, corruption, or bribery. So what we've seen, the complaints that we have received from members of the public is where a registered person will tell a member of the public that no, in order for your plan to be approved, you need to pay a certain fee so that we can pay a certain amount of money to a municipal official for a speedily approval. So we've seen this type of complaints. We are cautioning registered persons that please do not do that. Do not accept or do not engage in any act whatsoever of dishonesty, corruption, or bribery. Do not pay a municipal official bribery in order for your plan to be speedily approved. So if you come across this, you need to obviously you need to report the municipal official. But you yourself, you might not engage in that, because we have seen those type of complaints coming to SACAP. A member of the public will say, my plan has not been approved, but my architect has said that I need to pay a certain amount of fee in order for the plan to be speedily approved. So we are saying that you must not engage in those type of action, because you might find yourself that there is an improper conduct from your side. So we'll move to the next slide. Okay, thank you so much. We will also try to answer questions on the Q&A, and further there will be a Q&A. Thank you.
Thank you, Hauhelo, for that information. RPs we've seen through this presentation that firstly, getting into contract with an unregistered person, you need to formally write to SACAP to inform them. And also the great, a huge issue of candidates that open their own architectural practices. As candidates, you are not allowed to open your architectural practice. We need to inform the public further to ensure that whatever RP comes to them brings their registration certificate. Also, using the registration or allowing your registration to be used by someone else. You have your whole career and life ahead of you. You don't want anything linked to your registration and your registration number. So please try your best to protect that. What we found is RPs using architecture as a criminality. Forging a stamp. I know we are creatives. We've been equipped with the software, Photoshop, CorelDRAW. We've been equipped with all the softwares to make something very believable. Our sole initiative is to be creative and to make whatever we create come out on paper. But please, please do not use architecture as a criminality. Forging of stamps, we've had municipal stamps, multiple municipal stamps forged that we see. Homeowners Association, when a client has requested you to submit to an estate, you forge the Homeowners Association stamps. Please, please, can we try by all means? Because that's fraudulent. It becomes a matter of SAPS. Please do not use architecture as a form of criminality. Thank you, Khakhelo. Our next presenter is Mr. Sfanele Matembula. He will be addressing the misrepresentation of registration category and also taking over a project which has already been commenced. Thank you, Sfanele.
Thank you, Program Director. Good morning, colleagues. My name is Sfanele Matembula. I am from the Legal Department of SACAP. I will touch on the issue of misrepresentation of registration categories, as well as do a presentation on what needs to happen when one takes over a project which has already commenced. Perhaps as a point of departure, one must indicate that when we speak about misrepresentation of a registration category, we are basically speaking about instances where a registered person gives out false information which seeks to mislead the members of the public. If, for example, a person registered in the category of a professional craftsperson advertises themselves to the public as an architect, meaning he says he's a professional architect, that is misleading, that is misrepresentation. And in terms of the code of conduct, it is a contravention and it is punishable. So we've got rule 3.1 of the code of conduct, which specifically indicates that registered persons may only communicate and promote themselves and their professional services with honesty, describing both in a manner that is related only to the categories of registration represented in a practice. So at the heart of this rule, you will understand that we are basically speaking about ethics. Ethics is doing right, is knowing when there is right and wrong and you choose to do right. Whether someone is seeing you or not, you just need to do the right thing at all times. That is being ethical. We often receive complaints of improper conduct from members of the public and registered persons through the whistleblower platform against the registered persons who misrepresent their registration categories. This misrepresentation is included in social media platforms such as LinkedIn, Facebook, Instagram, websites, company letters, email signatures, and official company documentation. It is worth noting, colleagues in the profession, that if you contravene any of these rules in the code of conduct, you might be sanctioned, and in extreme circumstances, the sanction that may be meted against you could be a cancellation of your registration. So if your registration has been cancelled, it means your livelihood has gone out of the window. So you've just to be careful of how you conduct yourself to ensure that you do not find yourself in this difficult situation. Colleagues, it is also practical to have a professional taking over a project which has already commenced. A professional may take over another professional's project in instances where there is a professional arrangement between the RPs, the RP and their fellow colleague. This would be in terms of 2.2 of the code of conduct. Some other instances where one may take over a project which is already commenced would be where a contract between an RP and their client has been terminated, and another or a new professional is brought in to take over the project. So it is crucial for registered persons who take over another registered person's project to act with due skill, diligence, competence, honesty, and integrity. A registered person should not knowingly undertake professional work in circumstances or conditions and terms that would compromise their ability to carry out their responsibility and fulfill their commitments to their clients. A registered person who takes over and uses work which has been prepared by another registered professional must do so on the written consent and authority of the originating registered professional. Registered professionals are expected to only issue drawings, specifications, and documents in respect to work performed or administered by them or by a person in their employ which bears their name and registration number or the name of the agricultural practice. Registered professionals are obliged to sign and or identify building plans as having been issued by them if they are the bona fide authors of such plans or where the plans were prepared under their supervision. So it is important, colleagues, to adhere to all the rules of the code of conduct to avoid situations where SACAP now has to investigate, prosecute, and sanction you. I thank you.
Thank you, Svanele, for that presentation. RPs, I'm sure you've heard, a majority of the time, clients will approach you with another architect's drawings. That architect might have left them, or they might have not completed the responsibility. As another RP, you cannot take over the drawings or the work of another professional without written consent from them. It's clear, it's there in black and white. Please ensure we respect this conduct. Now, Kgaugelo, I believe I can hand over to you now. On our program, we have questions and answers that you will be able to answer. I don't know if you want to read any that you've answered on our chat box or allow members to ask. Thank you, Kgaugelo.
Thank you, Madam Chair. We may allow registered persons to ask questions if there are any. Then we will continue to answer the ones in the chat box as we go. There seems to be 3 participants raising their hands.
Yes, you may allow the participants to ask their questions.
Okay. Okay. Then we will allow them shortly to to ask their questions. We have noted the hands. Okay, Mbongeni Tembu.
Hello, can you hear me?
Yes, yes, we can hear you. You
Yes.
may go ahead.
Yes, I just want to know this part where the client comes with the work from another RP, and you don't actually get to get the previous RP's contacts to get that written consent whether you can carry on with their work. Now, in that case like that, how do we work?
Okay. Okay, so in that case, it means you have to facilitate authorization through SECAP. So you can send an email and then SECAP will talk to the other registered person, the initial drawer or designer, to find out if they know that their plans are being taken over, so that it can be facilitated by SECAP.
Okay. Now we've checked with the SECAP's a list of architects, because on the previous RP's drawing there is their name, but if we check from SECAP's portal, we can't actually find this previous RP.
Yes, so what you need to do is that you need to contact SECAP. So you will need to contact us. You can send an email at legal@secapsa.com, and then we can facilitate that from there.
Thank you.
Thank you. I will allow Robert.
Good morning. Can you hear me?
Yes, we can.
Good morning. Thank you for the webinar. I have two questions. One is the existing practices registration. Does that apply only to the registration of firms recently? I've been an architect for 40 years. Am I also expected to register my practice, which is a sole proprietary practice, with SECAP, or does my original registration from 40 years ago carry through? That's question one. Could you give me information, please?
Okay, in terms of your practice, what you need to do is that you need to list it with SECAP, register it with SECAP, irrespective of when did you start or when did you establish it. And then also you must take into consideration that there are no penalties currently as to as to the late registration. So you need to list it with us. So there won't be any penalty.
I will do so. I think that there are probably many old architectural firms that aren't listed with you. My second question is one in connection with associations with non-registered persons. If a builder is told by a client to form a team of architect, quantity surveyor, and structural engineer, and then to present a quotation, is that legal or is that not legal? You said earlier on that architects, registered professionals, should not make associations with unregistered persons. In this particular case, I know of a client who is approaching 3 different builders to get each builder to form a team of architect, quantity surveyor, structural engineer, and themselves to form a quotation, inverted commas, and that will be evaluated against each other. My concern is that 3 teams may very well work with different specifications. There is no brief in this particular case. How legal is that?
Okay, I'll just want to read Rule 5.6, perhaps maybe it would be clearer, because Rule 5.6 says that a registered person shall not, except with the permission of the council and under such condition as the council may prescribe, enter into any professional relationship or association for purposes of performing architectural work with any person who's not registered. So maybe perhaps we can just underline purposes of performing architectural work. Did I answer you perhaps?
Well, assuming that preparing a quotation on this is a restoration job, all right, project. I would read preparing a quotation for a restoration job under those circumstances to be illegal. And I need to advise the client or the potential client of this. But I don't want to do so if I'm wrong.
Yeah, okay. Now perhaps we should take this one offline so that we can understand the facts and the dilemma involved. So can you perhaps, we can send an email and then to legal@sacapsa.com, giving full detail of what is happening so that we don't give you a wrong answer.
I accept that. Thank you very much. Thank you.
Thank you. Okay, Anthony. Anthony, you may come in. Okay, there seems to be. Then we'll move on to Mr. Karma or Miss Karma. May you come through?
Hello.
Hello.
I don't know if you can hear me.
No, we can.
Okay. I've got two questions. The one I think is simple, and the other one I think I'm not sure how you're going to answer it. So I am a registered architect. I've been registered for a while. I have a registered company that is in my name. So those first two I don't think there's an issue with. The question for me is, if I set up a company with a number of other individuals that are not necessarily registered, why? Because the business of the company is not entirely architectural. However, in the event that one gets to do work that is indeed requires architectural involvement, in this instance, I would apply myself in my personal capacity under the auspices of the company. Is that possible? Yes. Or do I have to now take that new company name and register it under SACAP?
Okay. In terms of that, there is also Rule 5.4 on the Code of Conduct. It speaks to the majority shareholder and it speaks to multidisciplinary firms. So I think that that rule actually answer you, because it says that registered professionals and multidisciplinary practice shall not describe or name their practice as architectural practices unless the majority shareholding or voting powers are held by registered professionals. And 5.5, it says in any multidisciplinary professional firm which also practice architecture, a registered principal shall be responsible for the architectural work. And all provision of the Code of Conduct will apply. So I think this. So
in that aspect, if the work is required, that requires a registered person. If I am the one that is doing that work, then that means I am covered as far as this is concerned.
Yes, then it means you're compliant.
All right. No, thank you very much for that. The second question is this. I'm hearing you speaking about unlawfulness on the part of registered individuals. Okay. My question is, about individuals, all right, who cast aspersion on the professional conduct of a person like myself in terms of claiming that I am not registered, even within the space that says when you actually do provide enough details to actually show that I am indeed a registered profession. What does SACCUP do in an event when such aspersions have been cast? Is there a way in which I can appeal to SACCUP so that they can actually prosecute such entities? Because it's not just individuals, it's also entities.
Thank you, sir, for that question. I think the starting point would be to indicate that first and foremost, if we have to investigate any improper conduct or misconduct, we as SACCUP investigate such cases against registered persons. So if you have got a member of the public or any entity that might offend you with regards to your registration status, SACCUP ordinarily wouldn't have jurisdiction to investigate that matter or even to intervene. So I think that's the point of view from which you should approach such a scenario. Thank you.
Thank you, Mr. Matabula. Then we'll move to Mr. Ramlal. Mr. Ramlal, you may come through.
Morning, team. Thank you, and thank you for the webinar. I have two questions. Firstly, the one where you spoke about, the client signing a plan is good enough witness to see that the client would have signed the plans. As you're aware that, sometimes, we do email clients plans, and in return, the clients actually digitally, sign the plans or would give us a letter to use their digital signatures. How does SACCUP see that? Because then obviously it wasn't in person, it was done via email or whatever, for whatever reason. But is that acceptable when clients actually receive the plans and approve it and sign it and email it back to us? Because right now the municipalities are accepting that as in order. I just want to see it from SACCUP side. Will that be okay? That's my first question.
What I will advise is that if you are going to sign on behalf of a client, just make sure that you get a power of attorney for that specific.
No, I don't know. No, I didn't say I would sign on behalf of the client. I said sometimes the client would be happy with the plans you email to them, and then they would send you a digital signature where you have to transfer it onto the plan, and you could do an online submission. That's what I'm saying. They would give you permission in writing to use the digital signature. How does SACCUP see that?
Okay, because that is it's a little bit complex. So that's why I'll say that in order for you as the registered person to cover yourself, because now if you're going to copy someone's signature and put it on an official document, it's so what you need to do is that perhaps it's better to get a power of attorney for that specific client so that you can sign on their behalf other than copying and pasting their signature.
I think there's two things here. You might be just not hearing me clear. All I'm saying is because we have a system where if a client is far away and if you email the completed drawing you've done, and in return the client then sends you an email saying, I hereby give you permission to digitally transfer my signature on the plan, is that acceptable by SACCUP? That's my question.
No, we are saying that what you need to do is get a power of attorney for you to do that, for you to be able to sign. So it's signing on behalf of someone, copying and pasting a signature is not acceptable.
Thank you. That's my first question. The second one is not quite a question, but I think it's important with the difficulties the professionals are having in delays of approval of plans. May I suggest that you afford all professionals a SECAP email address so that they can CC SECAP when they are having delays in any building applications at municipalities, so that SECAP is informed before client takes any action against clients. So I think what would help the professionals is to keep SECAP updated that we have complied, and I think keeping SECAP updated would be on par.
Noted. Even better, you can actually send an email to our SR department and they will assist. So we've noted the suggestion. Thank you.
Yeah, I thought, if you could inform all the professionals of that email, and that would actually help greatly. Thank you. Yes. I have one more question. I'm aware that, municipal workers who are registered as BCOs and whoever at council, whilst they work for council, are they allowed to actually draw private work? Are they allowed to do private work? That's our concern. And how does SECAP see that? Thank you.
Ms. Capel, you come through. Did you have a question?
Have I not come through with my third question now? Okay.
Oh, no, okay. I heard you.
Sorry, Ms. Mashile, I'm answering on the Q&A online. Please, you can repeat, maybe I can catch it. I didn't catch it at all.
Okay. So the question is that can a municipal official submit building plans or prepare building plans? Did I copy that correctly, Mr. Ramlan?
Yes, what I'm saying is, municipal workers who work for the municipality, basically, some of them are registered with SECAP, and they do private work. Is that acceptable? I mean, this is in agreement? Can they do that?
Thank you. Obviously, only registered persons can render architectural work. So at present, if you are registered with SECAP, you are not prohibited from rendering architectural work, even if you are in the employ of a municipality. The only issue comes is that there's a lot of conflict that we've noticed. So we are actually working on raising this awareness to municipalities to try and curb the conflict of interest that we are seeing, because obviously we're now seeing that municipal officials are able to prepare building plans and submit them even to other municipalities, but the issue becomes that they know each other, and obviously we don't want that favoritism on plans that are prepared by their colleagues. So at present, yes, but we are working on finding ways to actually curb the conflict that we are seeing is happening in practice. I hope that answers you, sir. Thank you.
Yeah, I think, thank you. That's a good enough answer. May I ask one more question, please? One question, if you don't mind. Should municipal workers who inspect your plans at municipality, it is my opinion that every one of them should be registered with SECAP in some way, because if they're examining your plans, they should also be part of like CPD, to be well versed with what the changes, the regulations and stuff like that. Can SECAP look at that? That officials who are basically examining plans should be registered with SECAP. Thank you.
Thank you. We will look into that. Thank you, Sarah. We've noted that. Okay, we will move to Annette. You may come through. Okay, the same to be something wrong.
Who? Sorry.
Oh, no, you may come through
Oh, okay.
yourself.
I didn't hear my name.
No, I
Should
said
I?
it different. It's okay, it's all right. You
All
may
right.
come through.
Okay. Just in case, it is Chinedum if you were having problem pronouncing it. Chinedum. Okay. All right. Yeah, my question is, in the case of an RP taking over a job that has been started by another person, what if the person that started that job is not an RP? What would be the situation towards being compliant with the code?
If the person who did the work was not an RP.
Yes, it
So
does happen. A client calls you, he
Not
says,
registered.
not registered, not a registered person. But things happen. They draw, they design, they get paid even in some
Yes.
cases. And if such
Okay.
is given over to you, so how would you approach that?
Okay, in that instance, that person who did the initial or who did the initial drawing is not supposed to be doing architectural work. So
Yes.
what that person did, yes, it's a criminal offense. So they are not supposed to be doing it. So there's no need for you you are not taking over work from a registered person. You are taking
Thanks.
over work from somebody who's not supposed to. So you can take over that work because that person is not registered, is not supposed to be doing that work.
Thank you very much. So one would not be
If I may,
violating the code in that case. Okay, go ahead, please.
yes, I just wanted to come in there, sir, just to assist, to also state that we'll cover this later on in the presentation, but we do have several complaint affidavits that we have done. One of them is also to assist registered persons who want to bring such issues to our attention, so that you can also lodge anonymous complaints. You can bring this issue to our attention, obviously, so that we can deal with the unregistered person who was not supposed to be doing the architectural work in the first place.
Thank you very much. That's fine. Then another question is this. Often architects are principal agents. I mean, in our 6-stage work, those are the 6 stages of work for an architect who is a principal agent. Because if you are not a principal agent, I think some stages might fall away. Fine. Now, what I see in the industry, my personal observation, I think it's common. It happens. In the issuance of payment certificates, a quantity surveyor will do evaluation. In fact, in the industry now, they call it certificate. You hear, oh, has the QS issued the certificate? They said yes or no. Then often they will not even allow time for that principal agent who is an architect to do, in my opinion, the reason you are the principal agent, the reason you are the one in the contract who is obliged to issue a certificate. So they stampede and rush you. And what I'm telling you is generally accepted in the industry. That's why it's a problem. Everybody does it. So if you don't do it, you are the problem. Me, for example, will not just sign without scrutinizing, because it is the architect that has the contractual obligation to issue a certificate. Then when I take my time to study it or something, the quantity surveyors will complain that they have issued the evaluation, the architect is delaying signing it and issuing for payment. In fact, some other architects will side with them. And I'm saying to you, it's a general practice in the industry. So I'm asking myself, if RPs just sign QS's valuations perfunctorily, just like that, would that not be a violation of the code?
Okay, we are trying to comprehend your question, and because There's a lot happening. So I think
Let me,
what we
I can say again.
yeah, sorry.
I can explain again if you wish.
Yeah. Yes.
Yes, my concern is this, right? The architect acting as a principal agent, which is expected in most cases. The architect
Yes.
has the obligation to issue payment certificates at the regularity that is specified in the contract. Remember, that obligation is the architect's obligation. But traditionally in the industry, the quantity surveyor is the disciplinary expert for valuation, for placing monetary value to the work done. That's fine. So the quantity surveyor prepares a valuation. Then the architects issue a payment certificate on the basis of evaluation of the work done as at the point of issuing certificate. But I'm saying now, that obligation of the architects, it's a responsibility. It is the way it is practiced in the industry. It looks as if Mr. Architect just signed this and issue it's okay because the QS has issued the evaluation. But what if I do not agree with the amount valued? Remember, I am the one who has the obligation, the responsibility to protect the client, to ensure that the contractor is not being overpaid or underpaid. Then they see you as delaying the process. Unfortunately, because 90% or more of architects will just routinely just sign an issue. They just receive a valuation from the QS. In fact, the QSs call it certificate, not even valuation. The QS has issued certificate. Mr. Principal Agent, please sign so we can pay. The principal agent just signs and issues. And I'm wondering if there is not an ethics violation there of that duty of that person, architect, to ensure that the amount that is going to be paid to the contractor is correct reflection of the value of work at that time. But I'm saying across in our industry, it's generally accepted that you just sign it, that's all. So is it not a violation of the code of ethics for you to just sign, not caring whether it's right or wrong? Or yeah, I don't know. I hope I have explained it better this time.
Yeah.
Yes,
Good morning.
oh, okay, you can take it now. I was about to answer. It's okay.
No, you're free to do some, Ms. Logan.
Okay, I was saying from our side, I think it's a good practice that you are actually doing to actually check before you sign. Obviously, this is ethical, and I do think it's really unethical if people are just signing without actually checking, because this also affects the client. So it's not for us to say professionals that are involved in the project should not be involved, because obviously they're involved because of their qualification and obviously the terms of appointment thereof. But as the principal agent, I think all principal agents should actually be cautious before signing to ensure that everything is accurately reflected therein. And then for yourself as a professional or as a principal agent in that type of scenario, I think the important thing is that you must be able to communicate the issues that you are seeing on the certificate with your client so that they fully understand why you are actually choosing to say, first, I want to peruse, understand, and ensure that everything is correct. This will also help you in any event if the client is saying that you are responsible for delays, because should there be an issue that happens, obviously they will first come to you to say you are the one that approved. So I applaud you for being cautious, and I do think it's ethical for all professionals to actually look into these forms before they sign. I hope I'm covering you, sir.
Yeah, you make me feel very comfortable. Is there any other contribution from your side?
Mr.
Yeah.
Mr. Chiladan, thank
Yes.
you for your question. Thank you for your question. With regards to the QS versus the architect,
Yeah.
it is a duty also of a QS to issue payment certificates. it is also incumbent upon every professional to do their due diligence, right? So in as much as the quantity surveyor should do their due diligence, it is also incumbent upon you as a registered professional or architectural professional to do your due diligence in checking and verifying the work. Obviously not unduly so. It should never be with the intention of delaying a project, but it is very important for you to then, double check the work. But QSs are permitted to issue payment certificates and are well within their rights when they do so. But you have a valid point to say that, you have also a duty to check before you sign off. So I hope we have duly covered you. Thank you.
Okay, yeah, sorry, please, before I sign off. That is where I have a problem. That word saying the QS can issue a payment certificate. That's the problem. Because when you read all the contracts, there is no mention of the quantity surveyor. Anyway, just go and see. JBCC, name it, the principal agent, the project manager, or whoever. The quantity surveyor issues the valuation. He values the work upon which the architect will now certify for payment. I will tell you what I have done and tell you the costs, what is costing me. Hence, I'm coming to SACAP to say, please, am I protected? What I've done in some cases, because the quantity surveyors become resistant, sometimes they just say they're on holidays, they have traveled, they have done their valuation, please, they'll be back next month. And I need to issue this certificate the following day. So what I've done is, following the contract, I keep the valuation aside, I will include it and explain why I'm not issuing the amounts there, give my reasons, then issue my own certificate, state the amount I believe is fair at that point. And the clients, I have been fortunate for private clients, they have appreciated it, they have paid the amounts that I have recommended, but you see, I lose those QSs. I lose them. They never work with me again. And some other my colleagues, RPs, will support those guys because they would on their own just signed. In one case, it was the government. I don't know. I was queried. I was called to come and explain. Fortunately, 2 instances. Fortunately, I will explain and it will be accepted. And they will ask the QS to go and revise their valuation. But it doesn't always happen that way. And for me, to be compliant, to be ethical, and not delay the project, I say, thank you for this valuation. I'm not going to recommend this amount. Here are my clear reasons, and I'll write a certificate myself. I hope SECAP can give us, because we use JBCC now, I don't know whether SECAP can prepare us a standard format for issuing payment certificates for those who need. Thank you very much. I think you've answered my question.
Thank you, sir. Annette, you may come through.
Hi there, can you hear me?
Yes, we can.
Okay. My question is in regards to taking over work from from other professionals, especially in the case with COVID and other deaths that we've experienced. How do you take over work from an RP in the case of that RP's death?
Would that be, is it your concern that under such circumstances you wouldn't then ordinarily get consent to do the work? Or
Exactly.
Well, I don't think there's anything that can be done because when someone is dead, they are dead. You can't get consent. I don't think there's anyone who can even complain that you have offended and or infringed their intellectual property rights. They are dead.
Is it just the client that should give the consent then, or?
No. Remember, when you take over the work, it ordinarily would mean that the work has already commenced. You are just taking over. So the work would have been prepared by your colleague. In this instance, he or she is now deceased.
Yes.
So we are saying, when that is the case, there is no one to get consent from.
Further to add to that, Annette, is that in such an instance, obviously the death would need to be reported to SACAP first, right? We should be made aware so that should there be any queries, issues later, we are aware that you did not just use the intellectual property of one of your colleagues without consent, but rather that there was a death with proof thereof in the form of a death certificate or whatever the case may be. And then, as Mr. Matsebula said, there is then nobody to obtain consent from, but we would have been aware as the council of said professional's death, and therefore there can't
That
be
they
any
couldn't
further.
complete the project. Okay.
Yes, due to
Thank you very much.
impossibility.
Yeah, thank you very much.
Thank you. Ngoni, please come through.
Good morning.
Good
Thank you
morning.
for noticing me. My question is, what happens when an employee? I'm a registered architect and I'm an employee, and I engage allied professionals, for example, for them to give us services like electrical engineering or landscape architecture. And then with time, those people face challenges of them not getting paid by my principal or by our organization where I'm working at. And how does that become misconduct if I provide them with the communication details, contact numbers, and all that stuff of my principal, and then the principal fails to respond to them? But then this person who I would have PP'd or signed a contract with on behalf of the company then comes after me as an individual who is registered with SECAP. How do you deal with that?
So this means that it's a multidisciplinary firm, and then you as the registered person have controlling power of the architectural department of that practice. Am I getting it correct?
Yes. Then I have to get involved with, let's say, a landscape architect. We look for quotations, then we agree to say we are going with this one. Then after going with that particular person or that particular firm, and then down the line, our organization fails to pay that person. And then that company will then come after me as an individual, as Ngoni, not as XYZ company, as if I have misconducted. How does that become a misconduct on my side, even if I've provided them with all the necessary details to communicate with my principal?
So should we receive a complaint like that? So what we'll do is that we don't do a blanket approach. So what we'll do is that we'll investigate it based on the facts before us. And then because you are in a multidisciplinary firm, and obviously you are not responsible for the payment, we'll also take that into consideration, that it was not, it's not within your power to release the money. And then we also look at the fact that, hey, did you do anything reasonably possible for you to communicate to the person who's responsible to issue out the payment? So we will look at all those factors before we can get to a recommendation or a determination.
Oh, okay. No, thank you very much.
No problem.
Yeah.
Okay. We will go to Simon. Simon, yes, you may come through.
Thank you very much. Hello. Hello.
Yes, we can hear you, sir.
Okay. Thank you very much. My question is, how far is SACAP when it comes to the issues of unregistered persons who are reported in with SAPS? Because I am having a scenario which I was dealing with for 5 years, where I've been trying to trying to solve the issue of the municipality approving the building plans of unregistered people without engaging SACAP. When I saw that that is not working, I've engaged SACAP. The investigation were conducted, and we also proven, and the SACAP is aware, that the building inspectors, when they are a member of a public who's coming to the municipality, maybe wanting some data on his project, and maybe he find out he wants to know from the municipality any registered person, maybe a list of a person who can do the work. The municipal officials, they also issue a contact for people who are not registered to members of the public. That we have also proven with the investigating office of the municipality. That's my issue, because while we're still busy with that, we also published those people who are not registered. But we have just found out that this other person, which we have opened 2 cases against with the SAPS, is still practicing. And he also tell the member of the public that when he was questioning him about the approval, getting the approval in the municipality, he referred the member of the public to a certain individual in the municipality that officials, he knows how he's working with the unregistered person. Because another thing that I like SACAP to speed up on is the issue of cases that are reported with SAPS. Because these officials and the unregistered persons, when they don't, when there are no action which are taken against them, we actually, they continue to do these things. They continue to do these things, knowing that SACAP and SAPS, they don't do anything about those things. So mine was that we want to comply with everything when it comes to the code of conduct. But our issue is that providing professional services is very expensive. It's very expensive. You find in these cases, these unregistered people, you find out they are doing this work for 4,000 rand. And the municipality they accept their building plan, they approve them. That's issue number 1. Issue number 2 is that when it comes to building inspectors, they must be registered with SACAP. Because of one thing that is happening, they are outdated with the building regulations, and when we do the building plans, when we tell the clients that we have to comply with A, with Z, with B, and they tell these clients that no, we are wasting their time. I've got another issue with the municipality, with the municipal officials involving my client who was a client who was my client, who's also a director in the municipality, who took a building plan from me, because when I'm trying to ensure that the building plan complies with all the regulations, they took that building plan and the municipalities, they've given it to an unregistered person. The officials at the municipality, they approved that building plan. So the issue is that we've got building inspectors who are not registered with any profession, who are not regulated, who are not regulated, and who are not adhering to any code of conduct. Those things they are making our work to be hard. They are making our work for us to hard to do our works. So another thing, last thing that I wanted to bring into your attention, I have a project that I'm working on. On that project, during the site investigation, I've learned that there's an RDP house that has encroached to my client's building site. So I've drawn the building plan, submitted to the municipality, and indicated on the plan that the house has encroached to my building site. So now what is happening? Because there were delays in the municipality. They raised some issues, and when I confront them, they've withdrawn those issues. Now the issue that after they've withdrawn those issues, I've talked to the municipal manager, and I raised these issues. The one thing that the municipal manager told me is that he doesn't have power to dispute what the professionals are, to dispute whatever the officials are raising, whether it's a professional like a building inspector, a professional from fire, or from what we call a traffic officer. And they told me that they are not going to approve my building plan. So they have done that. They have done exactly that. They didn't approve my building plan. I don't know if maybe I can continue to read you the letter that they've sent to me, telling me that they can't approve this building plan because it's a violation of it's violating the rights.
Okay, thank you. It was a lengthy one. In terms of unregistered persons, what SACAP is doing is that there's a presentation specifically that's going to be speaking to unregistered persons. So I don't know, perhaps I should answer the question, or we could just leave it for that time. Because what SACAP is doing is that we are constantly following up with the SAPS regarding the complaints that we have registered, or regarding the cases that we have registered with the police, taking into consideration that jurisdictional issues, because we do not have jurisdiction over people who are not registered, and we rely solely on the SAPS. And then what we've done, or what we are doing, is that when we report those cases to SAPS, we make sure that they've covered all the elements of a crime. So usually the only thing that will not have is the proof of payment, that it can only be done by the police by going into someone's bank account. So what we do also is we follow up constantly on the cases that we've reported, and then on the presentation we'll share just few successful stories regarding those. And then also what we're doing is that we are constantly having engagements with NPA as well as SAPS to address the cases that are stagnant in the cases that we have reported, and then we don't see anything happening. So we do have constant engagement. You can see on our social media, we post whenever we have those engagements. And then regarding the conduct of the municipal officials, what I can say is that what we can do at SACAP, we can try to facilitate and find out why those municipal officials are acting in that specific way. So with that one, I will ask you perhaps to send us an email so we can look at the facts involved, and then we can see how best we can assist you. So the email can be sent at legal@sacapsa.com.
Okay, thank you very much.
Thank you. And then we'll move to Mr. Ramlal. You may come through, sir.
Hi, can you hear me?
Yes, we can.
Hi, thank you. Yes. So yeah, this is Dhiren Ramlal, Dean. So I run my own practice, but I'm also a board member of CYBID, South African Institute of Building Design, which is a VA recognized by yourselves. So we've had a few comments or queries that have come through once this code of conduct was announced, as well as the recent Facebook posts that SACAP has undertaken. And I think I've put some questions onto the Q&A, and I think most of it has been answered, but I just want to maybe just briefly touch on them in terms of association with unregistered persons. I think previously it was, and I could be wrong here, that that a person that is unregistered could be employed in a registered practice under the supervision of a registered professional. But I've been told that that's not the case and that the person has to be registered, or we'd have to inform SACAP. So that's just a comment. And then recently, in terms of, there has been a task team of representatives that have been appointed from each of the VAs to address municipal issues that SACAP has set up. One of the comments from the municipalities is that the professionals are submitting inferior work. Just like when we respond to the municipalities, they ask us for specific cases. We'd like them to respond with specific cases if possible. And then in order to protect the public, which is SACAP's mandate, what is being done to protect the professionals in this regard? Because our clients are telling us that we don't know what we are doing. So what is SACAP doing to inform the public with regard to this? I see on the chat there was some response to a similar query. And then a final one is in terms of the architectural office, in terms of contact details and contact hours, etc. I mean, working hours, etc. Since COVID, many practices have moved to their home and are working as home offices. One of the stipulations on that Facebook post was that hours of work and contact has to be displayed. Now that's a bit untenable, if I can put it in that word. Thank you.
Thank you.
Oh, sorry. Just one. There was a query earlier by a lady who asked about taking over. We talked about taking over work from a deceased architect. I think in that instance, I think first would have to be referred to the deceased's estate because there may still be fees due to that architect. Thank you.
Thank you for that question. Mr. Matibula will.
No, it's noted.
Oh, okay.
Thank you.
Okay, thank you.
I'm sorry, just one last thing before you respond. There was another query that I put onto the chat where if a practice is established by a technologist or a senior technologist, obviously they can't have architect in the company name. But if then subsequent to the establishment of the practice, an architect becomes a member of the company but has less than 50% ownership, can architect be used in the company name? So essentially the technologist may have 60% ownership and the architect 40%. The thing in the chat was that is not acceptable. I just like to know why.
Okay, I don't know if you can perhaps ask Melissa to mute. I don't know. Okay. Okay, thank you. I've managed to mute Melissa. Okay, with regard to the practice name, if it was established by a technologist, what Rule 5.4 says that registered professionals and multidisciplinary practice shall not describe or name their practice as architectural practices unless the majority shareholding or voting power are held by registered architectural professionals. So
Sorry, registered architectural professionals or registered architect?
Registered architectural professionals. And then in terms of the name, it's 5.9. So what the Rule 5.8? Okay. What Rule 5.9 says is that practice shall not use a type which portrays itself by name to be in a higher category than that of registered professionals who owns the practice. Yes. So if the architect is not is not a principal who's actively engaged in the practice and is not an architect, they may not do so. But if
No. No, I'm talking in terms of percentage shareholding. The architect is in the practice, is practicing, but it only has 40% because the practice was established by a technologist initially. And
yes, so they so okay, 5.8, the Code of Conduct 5.8, says the type of practice shall be determined by the registered category of registered principal actively engaged in the practice. So if there is an architect in the practice, it means you may call it Ramlal architect. Yes, who's a principal.
yes.
Yes,
But
so you may call it.
has less shareholding than the actual. So both are principals, but one has less shareholding because in terms of a CC, we have members, not necessarily directors.
Yes, so you may call
Thank
it.
you.
Yeah,
So
you may
I
call
think it
it.
may just need to be updated on the question and answers chat because that was why I was asking the question. Thank you.
Thank you.
Okay, Ms. Mashile, thank you so much for your questions and answers section. I'm looking at the time. It is 10 past 11, and I believe we are due for a tea or body break until we can continue with the rest of our presentations. So can we please have a 10-minute body break and be back at 20 past 11, where we'll be hearing the insight from Ms. Newa Malachi on non-compliance of the building regulations. Thank you.
Neat.
Good afternoon again, or morning again, all. We are back. It is 11:20. I trust everyone was able to get a cup of coffee or tea or use the bathroom. Just to be aware, we will have another questions and answers section at the end of this webinar. But at the moment, let's hear from Ms. Newa Malachi, who will be taking us through non-compliance with the National Building Regulations and other applicable regulations. Also, still be aware that any questions in particular to certain contracts or certain experience of architecture in the built environment, the SACEP staff is always available to answer. All right, Ms. Noel, please take us through, ma'am.
Good morning, everyone. Good morning, professionals and colleagues. My name is Newa Malachi, and I am a member of the SACEP Legal Department. I'm going to just take you through compliance with the National Building Regulation and other regulations. And by other regulations, we'll be referring to the municipal bylaws. As everyone is aware, every municipality has its own bylaws, the Heritage Act, and of course, the SACEP Act, Board Notice 7 of 2021. Building without approved plans is a serious violation of the National Building Regulations, which mandates that no person may erect, alter, add, or convert any building without prior approval from the local authority. And what we have found is that we do have complaints wherein registered professionals allow the building additions or conversions of buildings without the necessary approvals, resulting in sometimes the building having to be demolished, etc. So that's a serious violation and will result in misconduct at SACEP. As a registered person, when preparing your building plans, you're expected to comply with the National Building Standard and Regulation Act. You are prohibited from advising and or allowing construction in the absence of approved building plans. Furthermore, we need to comply with the National Heritage Resource Act 25 of 1999, which states that if a building is classified as a heritage building, you must ensure compliance and conduct due diligence. So for example, with buildings that are regarded as heritage sites or heritage buildings, when drafting a plan, you need to then submit it to heritage first, and then obtain that approval before going to the municipalities. The municipal bylaws, as a professional, you are expected to ensure that you comply with all necessary bylaws. So you cannot, ignorance is no excuse, sorry, is what I wanted to say. So it is incumbent upon you as a registered professional to familiarize yourself with the bylaws in your municipality so that you may ensure compliance. We cannot have an instance where you say, oops, I did not know. As a professional, it is your duty to make sure that you do know. With regards to Rule 2.2, a registered person shall, where reasonably possible, make appropriate arrangements for the fulfillment of professional obligations in the event of incapacity and or absence from work and or inability to perform work. This we've pointed out specifically because we have instances whereby members of the public are very frustrated. And as we've stated, they spend a lot of money, with these building projects, and they get frustrated because either a professional has become incapacitated, has relocated, is absent for a certain period of time, is overseas, and has not made any arrangements for the continuation of a certain project. And by arrangements, I mean that you as a professional can communicate with another registered professional, and it is yet again incumbent on you to make sure that they're duly registered and in good standing, and you can make arrangement with that architect or architectural professional to assist due to the fact that, for between this time and that time, you won't be available, or you're currently incapacitated, you're hospitalized, whatever the case may be, and to communicate. The other issue is that professionals feel that they need to communicate amongst themselves, but they don't need to communicate with the client, and that is very wrong, and it can lead to disciplinary hearings whereby you have frustrated your client, thus bringing the profession into disrepute, and that is frowned upon in terms of our code of conduct. So then you need to ensure that you communicate with your client beforehand, and in instances where you couldn't do so beforehand, at the first possible reasonable time that you are able to communicate with the client, the situation, and make the necessary arrangements. We have received complaints where registered persons have left the country without making arrangements for being absent from work for an extended period, and or have failed to make arrangements for the completion of their obligations to their clients in circumstances of incapacity. So make sure that you constantly work with other professionals so that in instances like that, you do not find yourself at a loss. Thirdly, we have the IDO compliance. IDO refers to the identification of work, and this is a document that is accessible to all professionals. I encourage all professionals to ensure that they are aware of the category of registration and what they are allowed and not allowed to do in terms of their category registration. A registered person shall only undertake architectural work which is identified for the category of registration in which they are registered in terms of Section 18 of the Act and by the registration categories in force. The IDO policy prescribes which category of registered professionals may perform architectural work in various circumstances based on their skills and competencies which are set out. The IDO policy provides the parameters for the various scope of work which each registered professional may perform according to their varying skills, competencies, and knowledge. These parameters are used to identify which type of work an architectural professional may perform based on their education, competence, project complexity, and building type. So it is very important to make sure that you do not overstep, for lack of a better word. You do not take on work that you know that you're not registered to, because this is a misconduct. And it leads, I mean, just if you think about it, it leads to a lot of issues when there's feedback from the municipality and you are undertaking work that you're not registered to do. Then there's certain things that you might not know, there's certain competencies that you might not have, and then that costs the client more. And the client is usually the public, and our duty is to protect the public at all times. I thank you.
Thank you, Ms. Malachi. For that, RPs, we've seen the presentation. Definitely approval of building plans is essential. Municipal approval, and where buildings are a heritage building exceeding 60 years, please ensure you submit to the right authority for that. Our next presentation is from Mr. Sfanele Atabula. He will be discussing competency and as well as candidates. Mr. Sfanele, please take the...
Thank you, Program Director. Thank you, Program Director, and thank you, colleagues, again for being present. I'm having a last bite now of the cherry. This presentation is with regards to candidates. So candidates must pay particular attention to this brief presentation because it applies strictly to them. Registered candidates are expected in terms of Rule 2.6 of the Code of Conduct to perform work under the direction, control, and/or continual supervision of a registered professional entitled to perform such work, and who must assume responsibility for any such work performed by the candidate. As SACAP, we are often confronted by a complaint where a candidate will firstly misrepresent themselves out to the public to claim that they are professionals, when in truth and in fact they are still candidates. And as a consequence, such candidates then begin to work independently without any supervision. This leads to frustration on the side of their clients or members of the public, in that the work that is often done is incompetent work because it is not supervised. The clients become unhappy, and the clients do not get value for their money that they would have paid. And as a consequence, this conduct brings the profession into disrepute. Similarly, candidates are not expected to open up practices of their own. The code of conduct frowns upon such practices. So it is extremely important that candidates, over and above complying with the entire code of conduct, they pay particular attention to Rule 2.6, so that they become aware that for any work that they might take, they have to do so under the supervision and watchful eye of registered professionals. That is all of this brief presentation. Thank you so much, colleagues.
Thank you, Sfanele. A very important point. Most of our investigations allude to candidates. Candidates, you cannot open your own practice. You have to practice architecture under a mentor. You have to be supervised. And in the case where we found you making any financial gains in opening a practice, we don't only go after you, we then charge your mentor as well, from not necessarily overseeing the work that you are prescribed to as a candidate. So please, let's ensure candidates, you are not allowed to perform any work and you're not allowed to open your own company to perform work as individuals, only monitored by mentors. All right, we'll move on to our next subject, letterhead and usage of the SACEP logo. Ms. Neo Malaji, please take us through the presentation. Thank you.
Thank you, Madam Chair. This is a brief one, but an important one as well. Non-compliance herein could also result in, even though a complaint comes to us at SACEP, we will investigate the complaint, but if you have a registered or established practice, it needs to be registered at SACEP firstly. So we would check if it's duly registered, and then we would check your stationery, one being the letterhead, to say, does it comply? So I encourage professionals, whenever establishing a practice, make sure that your letterheads comply with the following. The letterhead of your practice should display the name of the architectural practice, and as we've established, your name should not be in any form, manner, or shape a representation of your competencies. The practice number, so that would be the number that you would get from CIPC in terms of your registration. The type of practice, so in that, I mean, is it a multidisciplinary practice or is it an architectural practice? And the names of the principals and their registration numbers. So that should be clearly visible on your letterheads. Furthermore, the category of registration of the principal using the prescribed type. So for example, if you are a professional architect, it should state so. If you're a professional architectural technologist, it should state so. The professional designation and qualifications of all principals who are not registered with the council. So in an instance where you have a relationship with a member of a closely allied council, for example, you would then stipulate that in the letterhead to say, for example, engineer or whatever, it should be clearly stipulated that this person in the practice is not a architectural professional, but rather a professional registered with a different body and what that designation and body is. The physical and postal address, which should also include the telephone number of the practice, the email address thereof, the CIPC, Companies Intellectual Property Commission, and the VAT registration number if it is at all applicable to that practice. Practices of registered professionals may not display the council's logo on any corporate stationery or letterheads, as it is protected in terms of trademark laws. So we've also had instances whereby professionals, in order to, get the public to trust them more, they would put our logo on their stationery. That is definitely not permissible at all, and it constitutes a misconduct. Thank you.
Thank you, Ms. Malaji. RPs, I think that's quite straightforward. On your letterhead, practice number, category of registration for principals, VAT registration, and address. I mean, you do that once, and you use it with all your communications that you take out to your clients. That's pretty much straightforward. Please, it's one administrative function that you can do once, and then you ensure you comply. Otherwise, we'll add Rule 5.11 if anyone brings anything against you. All right, we'll move on then. Thanks, Ms. Malaji. We'll move on to Mr. Vuyo Nyaga, who will be speaking on performing while you are not registered. Mr. Nyaga, please take us through, sir.
Thank you, Madam Chair. Mr. Yaka is not available. I'll be taking you through performing work while you're not registered as how can we hear. In terms of the Architectural Profession Act, Act 44 of 2000, in terms of Section 18 of the same Act, it prohibits unregistered persons from performing architectural work. And then further, Section 41 of the same Act makes it a crime to practice without being registered. So this is goes to whether you were registered and then your registration is lapsed. So if your registration has been cancelled due to non-payment of fees, you are considered as an unregistered person, and therefore you are prohibited in terms of Section 18 from performing architectural work, which means that now your conduct is criminalized in terms of Section 41 of the same Act. And then this therefore means that if SACAP receives a complaint from a member of the public, and then we go to our database, and then we find that you are not registered, it will constitute a criminal offense, and then you will be reported to the police because Section 41 expects us to do so. Okay, we'll move to the following slide. So what we are currently doing is that at SACAP, we are engaging the South African Police Service as well as the National Prosecuting Authority, because we want to have a collaboration with them, because what we've seen is that because our Act, Section Act 44 of 2000, it does not give us prosecutorial powers, because those powers belongs to SAPS as well as NPA. So what we are doing is that we are collaborating with these two institutions to make sure that there's collaboration within the organizations. So we have Mr. Vuyo Nyaga. He is our IO. His job is specifically to deal with cases of unregistered persons. So what he does is that when he receives a complaint against an unregistered person, he prepares what you call ready for prosecution case before he reports it to the police. So he makes sure that when he reported to SAPS, the case is it's ready for prosecution, it's ready to go for trial. But because of the processes that we need to do in terms of reporting the case, what we do is that we report the case, but however, we do the investigation with the police in order to make sure that the case is actually prosecuted. So we are working tirelessly to make sure that there is a collaboration. We do this collaboration on a quarterly basis. We go, we visit police stations to address stagnant cases. So there are cases that we have reported to the police and there's nothing that's happening on them. So what we do is that because of the power that we don't have, what we do is that we try to collaborate with the people that have the power, which is SAPS as well as NPA. So we try to engage them, to collaborate with them, to see how clear we can assist in making sure that our cases goes for prosecution. So also what we do in terms of our goals for this collaboration is that we want to establish a clear communication channel. So we want to be able to, for them, if they need anything in terms of the cases that we have reported, they need to have a clear communication channel with us should they need anything from SACEP. So that's what we do in terms of collaborations. So what we've done is that, yes, because we are trying so hard to make sure that people who are not registered, they are brought to book, we actually have 2 legal cases that have actually went for trial and people were prosecuted for that. So we have S versus Madonna as well as S versus Madinga. So with these 2 cases, what we did is that we received complaints from members of the public, and then we did a case that was ready for trial, and then we reported to the police, and then we were available for evidence. We were available to give evidence. We are available to go to court as well as to testify regarding the contravention of our act. So what we've done is that we have 2 cases that it was a successful prosecution. So we are seeing progress in that instance. So the fact that what these cases actually mean in terms of us having a precedent is that it enhances the legal clarity for future cases. So because of these 2 cases wherein there have been a successful prosecution, there is a legal clarity in terms of future cases and in terms of the cases that we are receiving now. So we have a reference to say that in terms of these following 2 cases, there was successful prosecution, and then this is what we've done. So we are continuing to do what we did in the last 2 cases, making ourselves available to give evidence, making ourselves available to collect statements. So these 2 cases that there was a successful prosecution, they are helping in terms of national jurisprudence, and then they are also giving a clear clarification for the prosecutors when they come across such a case or such a crime, so to say. So we have a good reference. So in terms of what we want to do going forward, in terms of the police, we are monitoring implications on and future cases, and then we are sharing outcomes with key legal and enforcement stakeholders. And then as you can see on our website and also on our social media, we are constantly listing people who are not registered to alert members of the public not to do business with them. And then by so doing so, we are making sure that architectural work is reserved for people who are registered. And then also what we are doing is that in terms of our relationship with the law enforcement, we are making sure that we have this constant engagement with them so that we make sure that there's a clear communication, there's a clear line of communication between them and ourselves. So we are trying tirelessly to make sure that there is a clear communication, to the extent that we actually even help NPA when they need assistance with how they can structure their charge sheet to make sure that there is successful prosecution. And then our act and architectural work is reserved specifically for individuals who are registered and in good standing with SACEP. So in terms of unregistered person, that will be it, because what we do is that we make sure that we report those cases because of the fact that we don't have jurisdictions over people who are not registered. And also based on the fact that the power to prosecute is not on SACEP, but it's on SAPS as well as NPA. So that's why we are trying so hard to make sure that there's a collaboration between ourselves and those two institutions. So in terms of unregistered persons, I'll stop there.
All right. Thank you, Mr. Nyala, aka Gagelo, for that for that presentation. RPs, you know, it can be tough. Clients cannot pay on time. Cash flows can be an issue, but please ensure your annual registration is kept up to date. Please ensure you are still registered, your CPDs are in line, because once you practice and you are not registered, we have relations, as she has presented, with SAPS, where you'll be charged. It's a criminal offense. So please ensure that your registration is kept to date and you are in line with the regulations of SACEP. Thank you, Ms. Khaukelo. We'll then move on to Selina Miseko, who will be presenting on how to lodge a complaint with SACEP and the usage of the different complaint affidavits. There's a standard procedure for anyone who's of the public. It could be a client. It could also be another registered professional. If your colleague has stolen your work, or if your colleague is doing something not in line with our regulations, this is the steps that you can follow to ensure that you lodge a complaint about that individual. Ms. Seku, thank you.
Thank you, Madam Chair. I will be presenting on the complaint affidavit that SACEP has on our website. We have 3 different types of complaints affidavit. One from the member of public complaining against a registered person, and one from the registered person complaining against another registered person, and one where want to remain anonymous. All complaints lodged with SACEP should be accompanied by supporting document and also should be commissioned. Should you struggle to get the complaint on our website, you can contact us. We will email it to you, and we'll also advise on a way forward. Thank you.
All right, thank you, Ms. Segu. Short and sweet. Please go to our website for the process of submitting your complaints to any registered professional. Ms. Mashila, I'll then hand over to you for our last questions and answers segment. But I would like to, however, flag to the RPs any detailed complaint that is lengthy in nature. We have a lot more time for you to communicate it to the SACEP staff. So I'll open the floor along with Ms. Mashila on the questions and answers.
Thank you, Councillor. I will open up to Noah. Noah, you may come through.
Good morning, everyone. Thanks for taking the question. I'm going to start with the one question that I've already listed in the chat. And it comes from an earlier segment that was touched on where RPs are being cautioned about their registration details and letting them being used by various people in various scenarios. I won't outline them, we discussed them here. But my thing is, on a regular basis, we're being asked time and time again to disclose those very same registration details publicly, whether it's in a CPD, Literally just a second ago, we were told that on a letterhead, you must disclose all your RP information so that it's fully visible. And then at the same time, we're being told that we're going to get reprimanded should anybody take those same details and go and use them nefariously for other activities, with or without our consent. To me, that is a contradiction. And above all of that, where does POPIA fit into all of that? Because those are our details, those are our personal details. So there should be some measure to say, yes, SACAP is saying protect your details, but at the same time, we are being asked time and time again to disclose those very details. It's a contradiction. Can somebody just speak to that and give us clarity? That's the one question.
Okay, thank you for your question. Is it Noah? So with regards to your question, I don't think even in the presentation where we've asked for your personal details that are not, pertaining to your strictly to your qualifications and competencies. We have not requested your ID numbers or your personal home addresses or anything like that, because those, as you have correctly stipulated, are protected by the POPI Act. Furthermore, the punishment or the investigation is more in alignment with people using your information with your permission. So I think Ms. Mashile specifically said there are RPs who rent out their information, which means that they are aware that other people are making use of that information for various purposes. And that is what is a misconduct. So obviously, you do your best to protect yourself and your practice. For example, no one would know what your signature looks like or anything, because that's not freely available to the public. But it is on whatever document, whether we required it on your letterhead or not, it would be on whatever document. But everything is within reason, right? So we would not unfairly prosecute you for something that was you are not aware of, and that then becomes a criminal matter, which we would then assist you in registering as same. So I think we shouldn't confuse the two. What Ms. Mashile made reference to was when RPs are aware. For example, I had a case where there are two cousins, and the one cousin is a registered professional and she just signs off for another, or she allows her cousin to make use of her information and vice versa. So those are the kind of instances that we were making reference to. I hope you've been answered.
Okay, yeah, no, that's clear, and we can put that to bed. The second one is also, again, just rehashing another scenario of the taking over of work from somebody else. There's a scenario where that wasn't touched on that covers that situation. And that is, if somebody is wanting to take over my work, I'm not deceased, I'm not involved in the project, but I haven't been paid. Then I get a call from SACAP saying, there's another so-and-so RP that's going to take over your work. Do you consent? Now I've got a non-payment. How do we deal with that? That covers this. And am I, as a registered professional who hasn't been paid, am I allowed, or do I have rights to say, SACAP, I refuse flatly because this client has not paid me. You may not use my work.
Thank you for that. Yes, to put it quite simply, yes, you're well within your rights, because that is your intellectual property, and that is covered by various intellectual property laws. So yes, that is why we also require other professionals to seek consent. And then in those instances, you would then put it to SACAP to say, there is an issue of non-payment. This is my grievance, and this is why I do not grant consent. And You are, yes, allowed to just say, no, I don't want to, because it's my work. So you do have rights when it comes to that. Yes, we will ask, but that's why it's called asking. The answer could be yes or no. Mr. Matabula would like to add.
Thank you, colleagues. Just to add on the issue of disputes that you guys might have with your clients around the payments or non-payments. Look, when you enter into that agreement with your client, Rule 4.1 requires of you, amongst other things, to put a clause there that will deal with dispute resolution. Okay? So your client refusing to pay you and you being aggrieved by the non-payment, it's a dispute already. So how are you going to resolve the dispute? You simply go to your contract. What is it that you and your client agreed to do in such an event? That is what should guide you. Ordinarily, some contracts will indicate that in the event of a dispute of this nature, this is what we're going to do. We're going to solicit help from this person. We're going to solicit help from that organization, and so on and so forth. In other words, the fact that you might fail to resolve a dispute with your client is indicative of the fact that your contract might not be on par with the requirements of 4.1. I think that is where the issue should start. Have compliant contracts with your clients. These compliant contracts with your clients are the ones that should help guide you what to do when you are faced with this situation. Thank you, colleagues.
Are you covered, Noah?
No, I'm covered. Thank you Thank you very much. Thanks.
Thank you. We will let Lee. Lee, you may come through.
Good morning, everyone. Thank you for giving me the opportunity to talk. I would like to find out, I posed a question earlier and regarding, I'm a professional senior architectural technologist, my apologies. And I would like to find out, for example, for building types that is outside of my scope of work. I don't want to design them. I don't want to construct them. I want to offer a service to building owners to be able to legalize their buildings in the event where there is no municipal approved plans on file for them. Am I allowed to do this for a shopping center, for example, or should I partner with a professional architect to be able to sign off on it? Because I've done a lot of buildings in the past and I'm not allowed to use them because I did it for architects. So how can I go forward with this? Because I think this is a service that most architects neglect because everyone wants to design and build, and no one thinks of the guy that needs the plans in order to sell his house or property or whatever. I was advised in the comments on my message that I should email Naran. I did do so, but the email bounced back and wasn't delivered. And then I also had a follow-up question about the building types of my competency, on my competency certificate as a PSAT. Why is those not related to the national building regulations? Why is it different? Because it makes it difficult to actually, you know, it's sort of similar, but it isn't, it makes room for error easy. So those are my two main questions, please. Thank you.
Regarding the first question, because in terms of the work that you can do that is not within your category, if in terms of the code of conduct, if you are found to do work that is not within your category, it will constitute an improper conduct. So what you need to do is that you need to ask for, there's a special consent that you can ask from. Of course, it's a process on its own that you need to contact our registration department in order to inquire how you can go about that process. So I believe that if the email bounce back, please, you can try info@sakapsa.com and then it can be attention Nuran. So, and the second question, in terms of the certificate, with that one, it's a little bit technical, so I think perhaps it would be better if you send an email at legal@sakapsa.com for us to best look at the difference that you're talking to and then see how best we can respond to your email. Because just from the top of my head, because what we need to do is we need to see what is the difference so that we can see how best we can answer that question. So you can send an email. Okay. Okay, then I will let Nicholas come through. Nicholas Abrams.
Hello. Hello.
Hello.
I was unmuted, then muted back, and I was unmuted to ask, I think my question. Or am I still down the queue?
Yes.
I will patiently wait
Yes.
if I'm down.
Yes, you are still down the queue. So
Okay,
now
no,
we
I'll
were
wait.
going.
I will
Okay,
wait.
now we were on. Yes, okay. Now we were on Mr. Abrams. You may come through, sir. Nicholas. Then we'll skip Nicholas. Then we'll go to Mr. Ray Ramlal. You may come through, sir. Mr. Ramlal.
Hi, thank you. Thank you very much. I just have two questions. Compliance with regards to the NBR and other requirements is a very exciting one. Earlier, it was mentioned that if we allow clients to build before a plan approval, we can get prosecuted because that's illegal. I agree with that. How does SACAB look at is if a client has already built and then has called a professional to update the plan where it is existing, and we as professionals would look at it, not guarantee that the plan will be approved, but we will say we are prepared to draw the plan of what is built and then advise them any necessary changes that they have to make in order for a plan to be approved. Be that as it may, we would obviously take photographs and do the full site inspection as normal. But my concern here is if the building was already built and we've started the plans, and then the municipality goes and charges the client, will we also be penalized for this because we've got in at the second step, not at the first step? That's my first question.
Okay.
Right.
In terms of the type of complaints that we receive regarding that contribution is that registered persons are advising members of the public to build without approved plans. So if we receive a complaint and then we can see through evidence that you advise your client to start building, or you you took part in the construction before the plans were approved, then that one will constitute an improper conduct. But if you find that the client is already built without you, then there is no evidence that leads you to advising the client to contravene the National Building Regulations Act.
My concern in that regard is if municipality does take long and the professional who's done the work haven't given the client any permission to build, but the client builds, and then the client, when they do get caught, they say professionals gave them and they don't have evidence. How do you look at that?
Mr. Ramlal, I think the only evidence would have to be that you then would, I think we've repeated in our different presentations the importance of reducing things to writing. So you would need to have, cautioned the client to say, yes, I know you're frustrated with the long process, whatever, but however, I caution you, do not proceed with any building until we have obtained plans. That way, should the client do so, you can protect yourself in saying that I can't, I cautioned this client and they went ahead and they're an adult and there's nothing that I could have done about it.
Yeah, thank you. I think that's a good one. Thank you very much. I just want to move on to my quick second question. I acknowledge that we as professionals, whilst we are being guarded by a code of conduct in the services we do, and I think this is very, very professional, it's very good. Is SECAP saying that because the type of business we're doing is, and the services we provide, a code of conduct has to be in place? I'm now referring this to if we draw plans and our plans are submitted to the municipality, isn't the municipality also regarded as a organization where you pay money, and they should also be guarded by a code of conduct? Can we as professionals get a copy of a MOU or a code of conduct between SECAB and the municipalities, please?
We've noted that question, but in terms of the relationship between SECAB and municipalities, what we are doing now at SECAB, we encourage registered persons, should you have a problem with your plan being delayed by a municipality, you are encouraged to send an email to SECAB. What SECAB will do is that they will facilitate and engage with that specific municipality to find out what is the delay. And then what SECAB will also do is that you will be informed of those engagements, and then you will be provided with the feedback. So that's what we are currently doing in terms of the delays at the municipalities.
Thank you.
Thank you. Okay, then we will allow, Nicholas, are you there? See, I see you are not muted. Do you want to come through? Right, then we'll move to Jonathan. Jonathan, please come through.
Hi there. Thank you for allowing me the opportunity to speak. I hope I'm audible.
You are.
Okay, thank you. My query comes from the point of view of a local authority as well as a professionally registered person. I'm trying to figure out if there's a mechanism for local authority to report unregistered individuals. Is it the same process as you highlighted earlier, the two standard application or the complaints forms? And is there maybe a way to simplify that process specifically for local authority? Thank you.
You will answer that question. Thank you.
Yes, Mr. Jonathan, if you want to lodge a complaint, you can contact us or go to our website and download the complaint affidavit, have it commissioned, attach all the supporting documents that will assist us with the investigation, and send it back to us. There's an email address that you can use. It's legal@secabsa.com.
All right, thank you.
Okay, thank you. Thank you, Jonathan. Thank you, Jonathan. And then we'll open up to Nicholas. Are you still there? Okay, I'll just move on with Nicholas. As it's a Chine. Yes, you did say
Thanks.
how I
Thanks.
say. Yes. Okay, you come through, sir. You may come through. Chinodom.
Sorry, I muted myself accidentally. You can hear now?
Yes, I can hear you.
Okay, good. So the first question was, I have a hypothetical question. I did ask this on the chat room, but no answer yet to my hypothetical question. I am appointed as a project review consultant to review work on which there is a professional team complete. I'm not part of the professional team, but I'm supposed to do due diligence for the clients. Now, a scenario that I had observed previously, I want to be better prepared now to handle it. It's this: you have an architectural practice, they design the work, they start the work. But at some point, the registration of the principal lapsed of that company. So I did not accept documents that they signed as architects. I didn't accept those. Then what they did later is they submitted another person who was a registered person to be signing as architect, your forms A1, forms A2, approvals, whatever. Because for me, if I say I need the approval of the architect, I would mean a registered architect. So now, who is the authority? Is it the practice or is it that person? Because that person is registered, but remember, it is that practice that is listed as the architect on that project. I want to be better able to handle it this time. Please guide me.
Thank you, sir. Could we kindly ask you to send this query via email so that we can do the necessary research so that we can give you an informed response?
Okay. All right. Thank you. Next is now, if one is working from home, as many people have been doing since COVID, and one doesn't feel safe to put out your residential address on your letterhead, how do you handle that now? Because you're saying the letterhead must have the physical address of the practice. But one doesn't feel safe to just put your residential address out in the public, and one is working from home. What do we do?
Yeah, we just need to go back to our 5.11.
Yes, certainly, and quite regrettably, when these rules were enacted, I don't think they had envisaged such a situation to occur. But in any event, as things stand, Rule 5.11 requires of you to provide physical and postal addresses. I don't see how we can circumvent this just because we are fearful of providing our details. I don't know, maybe we can also have input from other colleagues.
I think you bring a valid point with regards to protecting yourself and the POPI Act if you are working from home. Like Mr. Matebula said, that such challenges were not envisaged in when this was drafted, because obviously we did not have instances of COVID, etc. So I think it's something that we will take up with the registrar to say, can we permit or have, I don't know, we will revert with regards to that in terms of maybe, because it says physical and postal address. So maybe allowing those who work from home and can prove that they're working from home to us, to just put their postal address, but it's something we'll take up and revert to all professionals in due course.
Thank you very much. Yeah, thanks. Is there anything else? Is that okay? You are done with that answer, I suppose.
Yes, yes, sir.
All right. Okay, now, can a refusal to provide consent in a case where one is taking over the work that somebody else previously started, if that previous registered person refuses to provide the consent, the written consent for one to take over, and if that refusal is unreasonable and unjustifiable, can it be overridden? And overridden by who?
Because I think when you give an authorization or withholding it, you need to give your reasons. If you want to withhold your authorization, of course you need to give reasons, and they should be reasonable reasons for me just to say that, because you can't withhold your permission unreasonably. So I just you can't just if you have been paid and then the relationship between your client and yourself is broken down, and there's nothing that is due to you anymore. You can't just withhold that authorization unreasonably.
Yes, thanks. I like that. So I'm saying where that happens, so what will be the remedy? Where consent is unreasonably withheld, what will be the remedy without violating the code?
Okay, so in terms of that, if you believe that the authorization is being withheld unreasonably, of course, that's when you will need to send an email to SECAP, and SECAP will see how they intervene.
Thank you very much. That's satisfactory. The last one is this. I've shifted now. Would it be an offense if one observes a violation being committed and fails to report to SECAP? Would that person be deemed to have committed an offense? Is one compelled? If one is compelled, please let me know the what they call it in the code, that the clause in the code that states so. If there is a clause that compels RPs to report violations, is it compulsory?
Thank you, sir. So there is no it is not compulsory in terms of the code of conduct. Perhaps it's just a matter of being ethical, understanding when a violation is being committed. If you want to report it, you can report it. If you want to do anonymous, there's a platform for you to be anonymous when you do so.
Also, just to add on that though, it should not be taken as a means to permit something unethical or illegal to occur and claim that you do not have a duty to report it, because in as much as we have an act and a code of conduct, we are also subject to the laws of the land. And one of it is the obstruction of justice. You cannot be found to be willingly concealing something that is happening in your ambit, just merely because you are not compelled by the code of conduct to report it. Because remember, at the end of the day, we fall under the laws of the land, being South Africa, and you cannot be found to be obstructing justice in any manner, shape, or form. So you need to be very careful also with regards to that.
Very important. Thank you for that answer. So that's why I wanted a very clear response, because sometimes there are issues of safety. You remember the same reason people are afraid sometimes to report some crimes to the police. Sometimes one has a reasonable apprehension, of one's safety or whatever. Maybe you are too close, or everybody is suspecting that this person is likely to report this thing. Sometimes it is so. So I'm not talking about one going out of one's way to obstruct justice, to defeat the ends of justice. No, it's one protecting oneself. Not protecting or preventing the matter from being reported, not at all. But just saying one doesn't feel safe to be the person reporting it. Is that person an offender? I need to know.
That's why we have provided for anonymous complaints, because we are aware of the safety element in this built environment, especially. So that's why we have catered for that in the form of anonymous complaints. And when we say anonymous complaint, we literally become the pro forma complainant. We say the matter then becomes SACAP versus whoever. So whoever the respondent is would never get to know who the complainant was. And it was specifically with your point in mind.
Okay, are you able, is this panel able to categorically inform the attendees to this webinar to say, if you don't report an act of violation, you are in violation? Are you able to tell us so that we know that it's a violation? But it would have been nice to also see the clause in the code. Okay, he already said there is no such clause. Are you able to tell us it is a violation if you don't report? Then we know.
We can't tell you something that is not in our code of conduct or our acts. As we've stipulated, there is no such clause. However, we did clarify that you need to just make sure that you're acting within the confines of the law. You're not obstructing justice, and that where possible, you access our anonymous complaints. And otherwise, there's no one who's going to come and say, you did not report your neighbor for whatever they did, because you know, it's not your duty. You're not a policeman.
In addition, say it would be quite difficult of us to even
monitor
what you know subjectively, you know, because we are not you. Don't know what you see and what you don't see.
Thanks, I'm very satisfied. Thank you.
Thank you, Stan. Kagiso, please come through.
Good morning, good afternoon. Thank you for the opportunity. Now, I just wanted to find out, this is in regards with the letterheads. I suppose this is basically on the letters, not necessarily on the title blocks, because I have seen in recent times that a lot of professionals put their previous seal on their title blocks, and it has the council's logo. I just wanted to find out if that is not in violation of the copyright that is on the logo. Thank you.
In terms of Rule 5.11F, it says that practice or registered professionals may not display sub-council's logo on any corporate stationery, letterhead, as it is protected in terms of trademark laws. So I think when you're referring to previous sale, because previous sale comes with SACAP's logo, it's not necessarily the registered person that is putting it there. So this rule 5.11F will not apply to that. But if on your letterhead you specifically go and look for SACAP's logo and then you put it there, you will be then contravening Rule 5.11F.
And also to add, this should also go for the websites. All those details should also appear on your website. Yeah, but like Ms. said, like your title, the previous sale comes from us, so we cannot charge you for something that you did not go out of your way to put.
Okay, thank you so much. And second question is that there has been an escalation in number of the verbal abuse that municipal officials are experiencing from the registered professionals. So can they also log a complaint, they are deemed as part of the public, which the council protects, then they can log complaints as well against those registered professionals, not just the property owners. Thank you.
Yes, we agree. Yes, so we agree. They can lodge a complaint against those registered professionals. Okay.
Thank you so much.
Thank you, Kagiso. Then we'll go to Serami. Serami, come through.
Hello?
Yes, we can hear you.
You hear me?
Yes.
Yes, let's greet everyone there. My question is so short question. I want to know if you will be qualified building control officer, like people approve our plans. Where is qualification you will be to be professional building control officer? Because I see the most of our municipalities, you run by the politicians, and the politicians, some of people you appointed at the building control officer to approve our plans. So I want to know the qualification of be professional building control officer.
Okay. Thank you for that question. And also, just before I answer that question, it's just that we need to also look at the importance of SACAP, because there are limitations in SACAP. There are certain things that the legislation allows us and does not allow us to do. So in terms of the building control officers at the municipalities, they are employed by the municipality, and SACAP is not involved in any way in terms of their qualification whatsoever. So it's just a limitation issue in terms of what SACAP can do and not what SACAP can do. And also, there is an organization that these individuals, if you believe that this individual is not qualified to be doing that work, then you need to bring it to the attention of SACAP. It's a regulation that looks at municipalities. Or even better, you can bring it through our SR department, and it can be escalated from that end. I don't know if I've answered your question.
Okay, no, thank you.
Okay, thank you. And then we'll go to David. David, come through. Then we'll go to, I think David has a problem.
Hello.
Yes, come through, ma'am.
Hello. Yes, good morning. How are you? Thank you for the presentation.
You're welcome.
My question is this. I'm just a candidate. I am working under mentorship. And my question is, using the client architect agreement, has got the SACAP logo on. And for one to use it for a client, would the RP have to copy the client architect agreement that SACAP has and put it on their own letterhead? Or would how would one use your client architect agreement?
Okay, in terms of that document, if you are using it as it is, you may use SACAP logo because it's a SACAP document. So, but if you are going to copy the content of the document and put it in your letterhead, you may do so. But what is concerning is that as a candidate, you are not supposed to be entering into an agreement with members of the public. It must be done so through you. Yes, through your mentor. I just needed to, yes. So, but if, it's for registered professionals.
Yes, the thing is, using the SACAP client architect agreement, using the SACAP logo that's on there, and also the intellectual property rights, I see a problem with copying it onto like the company letterhead. And there's also a problem with using the SACAP logo. And that's why I wanted clarification on that.
Okay, so what I'm saying is that if you are using the document as you download it from our website, it's a SACAP document. So you can use it with the logo. But if you want to copy the content of that agreement to your letterhead, you may do so, but without copying the logo. So you can copy the content in order for you to comply with the Rule 4.1. But you cannot copy it with the logo. So yes. Okay.
Thank you for clarifying that. Thank you.
Thank you. Okay, so we are, David, are you able to come through? Okay, then we'll move to Nelisa. So before we go to Nelisa, we'll move to Makina. Makina, please come through. Sorry, Nelisa.
Hello, thank you for the opportunity. I really appreciate what the SACAP does for us. But I would like to recommend that SACAP should do follow-ups on the like cases where we complain against people that have, maybe I had a situation that somebody was using my registration. And I did report, and I really struggled. They stopped, but what frustrated me was that somebody actually built a house with those plans. And when I was asked by the police what they should do, I instructed them that they need to withdraw the approved plans. On the context that if the plans were fraudulently submitted, even though they were approved, they were still fraudulent. But the municipality said to me, no, we already approved the plans, so there's nothing we can do anymore. I feel that's like saying somebody got an ID fraudulently, and then Home Affairs discovers it and then still says, no, they can keep the ID, even though they fraudulently obtained it. So I'm in that position where plans that were fraudulently approved got built, and I instructed the police officer that should be withdrawn, but nothing happened. So I'm just recommending that SACAP should do follow-ups. People are really messing with our profession. There's many things that we could report, but we feel like nothing happens, and therefore it's draining. We just let it go. Thank you.
We note that. We note that. Thank you so much. Thank you. We'll then move to Nelisa. Nelisa, please come through. Nelisa? Okay, then we'll move back to David. David, are you able to come through? David Ngoma? Okay. Okay, then we'll move to Mr. Van der Merwe. Mr. Van der Merwe, are you able to come through? Okay, I'll ask, let me see if maybe there's an issue here. Yeah, I'm just gonna try to see if perhaps David can hear us. David Ngoma, can you hear us? Okay, let's go. Let's move to Mr. Swanopu.
Hello, can you hear me?
Yes, yes, we can hear you.
Thank you. I posted questions mainly about the CPD for the session because the emails are coming through without all the details. So the images normally don't come through in the emails. Only the registration link. How do we, what CPD is on the session and how do we get those 6 credits?
Okay, because this code of conduct webinar, it's a category 1. Yes, it's category 1, 0.46 points. So there will be, yes, so because we are on Zoom, Zoom will constitute an attendance register for our CPD department, and they'll be able to see your name from there.
Okay. The other thing is about the session.
And also,
yeah.
Because also you are requested to register, so they have your details in terms of that.
Oh.
Yes, you may go. Yes.
Okay. Will there be a recording of the session, because the information here is very well, and I think it's going to be a good session for me and my team in the studio to work through, so that everybody in the team is on par with what you've discussed and how we apply that inside our practice.
Yes. We are actually live also on Facebook, so the recordings will also be accessible from Facebook. And then, yes, so we can also be able to share the presentation with our registered persons.
Okay. The Facebook recording sometimes is an issue with the Office network that doesn't allow social media platforms.
Oh, okay.
So
then we will share the presentation.
Thank you.
Thank you. Okay, thank you. I don't know if there seems to be an issue with David Ngoma. Okay, David, are you able to come through? Okay, I'll move right along. Mr. Van der Merwe. Mr. Van der Merwe, are you able to come through? All right. Okay, I'll open for Mr.
Hello.
Hello. Yes, Mr. Mtembu, please come through.
Okay, good day. Yes. My question is based on that Rule 5.1 on the companies. That within 30 days of registering, as you must declare the company to suck up or inform suck up. I don't know if I got that part well.
Yes, Rule 5.1 expect that within 30 days of the establishment of the practice, you must register it with SACEP. So in terms of, okay, maybe I should actually listen to the rest of your question.
Yeah. It's like my case is I had been doing construction work and then got to register as a candidate recently. Now, I wasn't aware that if I'm already having a company and registered and registering as a candidate, then I'll have to. But my company is doing yeah, just to get a light on that. That's what I need.
Okay, so what the Rule 5.1 says is that any registered principal who practice architecture in any form. So this is for when you are practicing architecture, you need to register it with SACEP. So, but if your company is a construction company, you don't need to list it with SACEP. But now the issue, because there seems to be a layer of other rules that you need to comply with, because seeing that you are a candidate, there's a rule 5.10 that specifically speaks to candidates. It says that A person registered in the category of candidate shall not establish an architectural practice, act as a principal or a shareholder in an architectural practice. So this is for Rule 5.1 specifically speaks to practices that practice architecture.
Yeah.
Then they need to list their practice with SACAP.
Okay. I guess I'm clear on that now. Thanks.
Thank you. Okay, then we'll move to, I just want to see if there are no hands. Okay, can you move to Noah? I don't know if you've spoken already, Noah.
No, thanks. This is a different question, and it's more directed directly at SACAP this time. With all that's being said, with information in terms of how SACAP is dealing with certain things, I think the one case of where there was an RP that is saying that what do they do in an instance where a member of the public is bringing their name into disrepute by, tarnishing their image type of thing. And SACAP's stance of basically saying, look, that's between the member of the public and the RP. The general sense, and I know it's not the first time that you guys will have heard this from us as RPs, is that SACAP needs a little bit more teeth. So I don't know if SACAP can take us all into confidence and say to us, what is SACAP doing about that? Because you've openly disclosed the fact that you guys have a limitation in terms of your mandate currently as it stands now. So what is the long-term plan? Are we going to stay where we are in terms of your limited powers, your limited means of acting, your limited ability to prosecute, all of those kind of things? And you can take that conversation all through to the biggest gripe that lots of the members here have, are the unregistered people that are doing what we are supposed to be doing, that are undercutting us, they're undermining us, they are bringing the profession into disrepute. And how active that campaign should be in tangent or in hand working with, informing the public that a certain scope of work is supposed to be limited to a certain group of individuals. That, in my understanding, is purely a SACAP mandate, unless I'm wrong. You can correct me if I'm wrong. But we've got floods in many provinces, the most recent now in the Eastern Cape. KZN has been torn to shreds with things, and there's tons of things that are speaking to non-compliance within our sector. And SACAP is there in the mix to some degree. So I'd like to understand what is SACAP is doing about that, because there's a huge role that you guys should be playing, to bring the public up to speed, not us only, but with your assistance. Can somebody fill us in on that, please? Thanks.
Okay, thank you for that question. And then in regard to how SACAP is dealing with unregistered persons who are doing architectural work, is that SACAP is actively, we are on the ground working on that. If you can go on our website, you can see that we are constantly engaging with the SAPS as well as NPA in order to find a common ground, and also to make sure that there's clear communication between the two. And then also what we do as well as taking it further is that on a quarterly basis, we list, because we work on the complaints that we receive. So what we do is that we on our website, on our social media platform, we list individuals. If we have received a complaint from a member of the public and we search on our database, we find that that individual is not registered, we list those people on our website to alert members of the public not to use that person anymore. And then what we do, we don't just leave it there. What we also do further is that there is an individual, Mr. Vuyo. He was employed specifically to deal with unregistered persons. What he does is that with his police background, he makes sure that when he will report a case to the police, that case trial ready, so to say, that there isn't much work that the police need to do in order for it to go to NPA or for it to have to have a successful trial. So, and then also what we do is that Mr. Vuyo makes himself available for giving evidence should the matter goes to court. And then what he does also on a daily basis is that he follows up on those matters to make sure that they are successful prosecution. And then also when you see on the presentation that I presented for Vuyo is that we've made so there are some few or two successful prosecutions that have been done, that people went to jail and then they were prosecuted. And then what you can see also, we try to put it on our website whenever a person is being arrested for contravening our act. And then also, we also try to make sure that in order for them to get a harsher sentence, we combine the contravention of our act as well as fraud. So we are working tirelessly to make sure that people who are not registered are not doing architectural work, to the extent that there's a person that is specifically employed to deal with that, and then the work is being done. Thank you.
Thank you for that.
We'll move to, I think we haven't had anything from Denver. Denver, you can come through.
Hi, good day. And thank you for this opportunity. Yeah, I actually have 4 concerns, right? The first thing is, I actually am a registered professional, but I'm also a building control officer at the municipality, right? And what basically happened, I think it's more than a year ago, I reported a case where a certain person actually submitted building plans, and he actually completed all the forms, signed the building plans, and he actually indicated on the prescribed forms that he's a registered architect, right? I reported that to SACAP, and then everything just went quiet. And last year, I actually followed up on the issue, and someone actually, one of your colleagues actually came to see me in the Western Cape, flying down from Joburg to the Western Cape. I actually did give an affidavit whatsoever, and till date, I had nothing about this case. That's the one concern, right? The other concern is like, it was also brought under my attention that there's a certain individual, right, that actually have business cards printed, and on the business card, they actually clearly states that he's an architect. But I actually went to do my investigation, but he's not an architect. He's not even registered as an architect. He's registered as a senior technologist. I spoke to a registered professional, and he actually indicated that he even reported that to SACAP, and nothing has been done till date. Then you also have the case where other registered professionals, right, are going around and spreading rumors that this specific registered professional is not allowed to do building plans, blah, 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 blah. What can one do about that if another registered person are actually spreading false news that another registered person is not allowed to do plans, although that person are actually registered in terms of the Architectural Act and is in good standing with SACAP, right? That's actually concerns that I actually really want to actually bring on your attention, and I just want to know actually what are you guys doing about it, because the first case of the person that said he's actually a registered architect was reported. Affidavit has been completed and submitted, and nothing according to me. The case is quiet, and also the other case, which is really a concern, other people that actually print business cards, spreading it out to the public and say they're architects, but they're not even registered as architects. Thank you.
Thank you, sir. Sir, we are firstly going to have to apologize for this apparent delay in terms of resolving your complaint. At this point, we are not aware of who you would have given the information in the affidavit to, but for what is worth, can we kindly request you just to send us an email, legal@sacapsa.com, with all the information that we can do proper follow-ups and see if we can provide you with the status updates. I think that should suffice for me.
Okay, yeah, and just one other thing. What actually the other concern is like I actually stated is like what do you do in a case as a registered professional, legal registered professional person, right? That's spreading rumors like that person is doing fraudulent stuff. That person is not allowed to do architectural service. Can I actually lay a complaint against that registered professional spreading false news? Or what do I do as a
Yes,
registered professional in that regard?
Yes, please feel free to lay a complaint. It will be investigated upon.
Okay then, thank you very much, sir.
Thank you. Seeing that this webinar was scheduled up until 1 o'clock, I'll just go along with our program. I don't know if maybe let's try to take one, the last one who hasn't spoken before. Maybe I don't know if between Mr. David, are you able to come through now? Right. Then we'll then move to Robert. Robert, are you able to come through? Then you'll be the last one.
Hello, ma'am.
Yes, you may come through. Yes, I can hear you.
Hi, my question is about a warehouse development being designed and carried out by a registered architect. The architect now finds that a section of that warehouse is a highly technical, highly specialized facility for a pharmaceutical subtenant. The question is, the subtenant has employed somebody who is not in the category to do that work. To what extent does the design of the pharmaceutical graded storage area within the warehouse fall within the identification of work reserved for professional architects, as opposed to other categories of registration, such as professional senior architectural technologists or technicians? In other words, it's not only in this particular case, but it could be in a heritage situation as well, where you have a category architect doing the work, general work, and a heritage practitioner or somebody pretending to be a heritage practitioner who's not in that category doing the inside work. How does that work out?
Okay, because now I'm trying to think from the top of my head what the code of conduct says. I believe there is rule 5 or no, rule 2.3 that says that registered persons shall only undertake architectural work which is identified for the category of registration in which they are registered in terms of section 18 of the Act and in accordance with the registration category in force, which in this instance means the IDOW. So what SACAP would do that if they find that there's an instance where you are doing work that is not within your category of registration, it means then now you are contravening rule 2.3 of the code of conduct and it's an improper conduct. So if you come across that, you will need to report to SACAP so that SACAP can do an investigation and then take it from there.
Thank you. And then just a comment. The requirement to have one's postal address on one's letterhead is becoming questionable in South Africa because, for instance, here in Durban, the postal office in Seaview has been closed. We have shifted over to Rossborough Post Office, which has been closed. There is no street delivery. Surely you should be talking about a physical address, because if you want to send the clerk of the court to address your case, yes, you need a physical address, but postal addresses in South Africa have become a fictitious item.
No, we note that. We note that. Thank you so much.
Thank you very much. Thank you for a very worthwhile webinar. Thank you.
Thank you. Mr. Robert was the last question that we're taking. Thank you so much. I'll take it back to Councillor Singer. Thank you so much.
Thank you. Thank you, Hachero. Thank you to the SACAP team. Yourself, Bessie, Svanele, and Neo, you and well as Miss Selena Seku, you guys have outdone yourself in ensuring all our RPs are well informed. I think these code of conduct webinars are very important for everyone to gain a full board of knowledge. So thank you to yourselves. Colleagues of the built environment, registered professionals, as well as members of the public that have joined us today. I believe it was very much worthwhile. So I thank you for your attendance. And again, any questions left unanswered, any questions that you require to be answered to, please ensure you contact SACAP for those. So officially, I would like to deem the webinar closed. It's been worthwhile. I hope everyone keeps warm and has a good weekend. Thank you so much.
Yeah, thank you.